Welcome to our presentation on Trademark Smart, how to build a strong brand and prevent infringement issues. We are the Trademark Place. We are a law firm that has a client-first approach. We like to make ourselves accessible to our clients, but above all else, we care about what we do. We love being trademark attorneys. I am Alec Allen Ross. I am the founder of the Trademark Place. I started this firm with the idea of having a law firm that would be not only accessible to people, but also affordable. That was important to me. So let's get into what we're here for. Let's talk about branding, right? So when we're talking about branding, there's a few things that we want to look at when we're doing a brand. One, we want to make sure that the name or logo or whatever it is we have is both creative and unique. At the same time, though, you want it to be simple. You don't want it to be overcomplicated. It needs to be relevant, and when I say relevant, what I really mean is important to you. Because if it's not relevant to you, it's not going to be to anyone else either, right? That's very important to keep in mind. You want it to be memorable. You want people to walk away from it and not forget it, right? And you want it to be versatile, meaning hopefully whatever brand or company you have is going to grow over time. And you want your brand to be able to grow and evolve with your company. So let's take a look at a couple of pretty famous trademarks here, right? Anyone not recognize these? The crown, that's Rolex. That's Rolex. Yeah, that's the trickier one, right? That's probably the trickier one. But what do all of these have in common, right? So what do these brands have in common? Well, first of all, they're very simple, right? There's nothing overly complex here with any of these. And they're also very memorable. When you see one of these, if you know the brand, you know what it's for. You know what goods it's for. You know what services they're for. It comes to mind when you see their logos. They also have something else in common, though. They're all protected. They're all registered trademarks. So it's important that you don't just create your brand, but you protect it. You file the registrations, and you get that protection. So what are trademarks, actually? So a trademark is any word, phrase, or design, and design can be anything, right? A logo, the shape of a bottle, a color, whatever, right? That identifies your goods and services. And what do trademarks do? Well, as we just said, they identify the source of goods and services. When they see your name or your logo, they conjure your goods, right? They know where it comes from. Beyond that, trademarks distinguish your goods from other people's, right? So if you're branding something, you have it out there, and someone goes to the store with the idea of buying your goods, your products, they don't buy your competitors out of confusion, right? They buy yours because they know what brand it is. And then trademarks also offer legal protections. It's very important. So let's talk about why trademarks are important. One, so as I kind of said, it can protect you from being sued. Obviously, it doesn't protect from all lawsuits, right? Anyone can be sued at some point. But trademarks help protect you from your brand, right? You can't, someone else tries to steal your brand later, they can't just sue you if you have the registered trademark, right? Because you got it first. It also builds goodwill or equity, not just in your industry, but amongst your clients and your consumers. And by goodwill, here's a way to think about what we mean by that, right? So if you're around 6 months, a lot of people haven't heard of you, but if you've been around for 6 years, people start to trust you more, right? They've seen you, they know you're not going away. That's goodwill, and you can't buy that. You can only earn that. Trademarks also allow you to more easily defend your brand, right? So think of it like if someone comes around and just starts using your brand or elements of your brand to steal your customers, with a registered trademark, you can stop them, right? You can say, hey, cease and desist, that's my brand, you can't do that. It also saves you time and money, mostly from the standpoint of one, the lawsuit thing, but also from having to rebrand, right? If you don't have a registered trademark and someone then sends you that cease and desist, guess what? You're losing a lot of money. One thing that people don't think about with trademarks is they're valuable assets, right? Trademarks are property, they're intellectual property. And just like any other kind of property, trademarks can be bought, they can be sold, they can be borrowed, they can be licensed out. They're property, they're assets. And lastly, trademarks last forever. As long as you continue to maintain it and renew it, it's never going to go away. Look at Coca-Cola. They've been around for like 100 plus years. Probably going to be around for another 100 years. So how do you get a trademark? The first thing that you want to do is a comprehensive search. It's not required, but it really kind of is, right? So what is a comprehensive search? A search is looking to make sure, one, no one already has your trademark registered, or two, no one has a trademark that's too similar to yours that's going to cause problems for you later on. So how do you do this? Where do you search? First thing, and probably the most important, you're going to search the USPTO. That's the United States Patent and Trademark Office. They have a database. You can look, see not only the ones that are registered, but the ones that are filed. You can even see the ones that failed, right? The ones that weren't successful. You want to search there, not just for your name, but for similar names as well. After that, you want to look at common law searches. There's a lot of different places to look for this. You're going to look on the internet through Google, Bing, that sort of a thing, but you're also going to look at social media. Who's using it? How are they using it? And then also, lastly, you can look at state trademarks and business names, right? These don't have federal protection, but they could cause problems if you aren't aware of them. So let's look at a quick case study. Let's imagine for a moment that I want to start a new brand. It's a clothing brand. It's going to be, all trademarks are in classes, right? So a class helps the government know what type of good or service you're providing. So let's imagine I have this clothing company I want to start. I think it's going to be big. I think it's going to go places. The name, it just kind of came to me in a dream one night. It just pops. It really pops. Liebach. I think this is the one, guys. First thing you want to do is you want to do a trademark search. You want to make sure no one has this name. So I go to the USPTO database. I look this up. And guess what? No one has Liebach in clothing. Guys, this is a slam dunk, right? I'm filing this trademark as soon as this seminar is over. I'm going to go back, file this. No one else take this. This one's mine, all right? I found it. You see it here. But before I do, I should probably do a couple more searches, right? I should probably make sure that there's nothing too similar, right? Because no one has the exact name. No one has a Liebach in clothing. But maybe there's something that has an Ebach in it. I don't know. Let's see. Reebok. Man, I missed that one. Looks like I'm not going to file this trademark after all. You'll see here there's also a Weebach. Weebach is actually Reebok. If you look at the owner, it's the same one. I do want to point out there is a Reebok that's very colorful that's not registered. That one will not become registered. It will be denied, and it will also, if they haven't already, receive a cease and desist at the best. It could get worse than that. But let's imagine for a moment that Reebok didn't exist, right? That there was no Reebok. This search probably would have shown no results. It would still look great, but it's still not a very strong search, right? I'm just looking for things that end in Ebach. I want to do a more comprehensive search, and you'll see up here, there's a complicated search string. It has stars, it has brackets, it has slashes, it has plus signs. All this is doing is making additional variables in the search, right? Broadening out that search to include other types of things. And what we see here is a Liebach, right? This L-E-B-A-C, Liebach. That doesn't conflict with Reebok. It's far enough from there for it to exist. But with my Liebach, it would still be a conflict, right? It's starting with that L-E, it's centered with a B, and it's an ak kind of a sound at the end. That's going to be a conflict. If I'm a trademark attorney, and I am, I would advise my client not to register this trademark. Rebrand, right? You haven't started yet. Start strong, don't start in litigation, right? Just don't do it. So that's looking at it from the search standpoint. But we also want to look at how strong a name is, right? So it's not about just no one else having that name. You want people to remember it. So remember, trademarks are source identifiers. They identify your goods and services. What you don't want to do, if you can avoid it, is have a very generic name, right? If you're in the clothing company, you don't want to try to trademark tennis shoe, right? You're not going to get that, first of all. It's generic. But even if you could, you couldn't protect it, right? Because it doesn't identify who it's coming from. Nike sells tennis shoes. Reebok sells tennis shoes. It's not going to help you in the end. So what you really want to do is you want to come up with a unique name. I say it here, make it weird, right? You don't want it to be something that just falls, between the cracks. You want it to stand out. Think Yahoo, think Google, right? Do those names mean search engines? Well, now they kind of do, but that's because of their prevalence. When they came out, who laughed at Google? It's like, what kind of a name is that, right? Well, it's a name that has staying power. That's what it is. So make it weird. Make it something that people will remember. So how do you get a trademark? What does the trademark process look like? I like to break it down into 6 steps. The first one is simply the preparing and submitting the application and paying the filing fee, right? That's the first step. It's also one of the most important steps because you get a priority date. I'll mention that again. Next, you're going to wait a long time for the government to review it. Currently, it's taking about 9 months for them to review it. That's okay. You'll have that priority date, and it's okay. Just know you're going to wait. After that, once they do review it, you're going to need to respond to any issues that they have, right? If they find issues and you don't respond, guess what? All the money and time you spent is gone. It's gone. Once you do respond successfully, it goes on and becomes published in something called the Official Gazette. It's going to be there for about 30 days, give or take. And the purpose of this is to let other parties have that chance to defend their own trademarks against you if they think your trademark is too similar to their own, right? So they can't do it to steal your brand or anything like that. What it is, it's saying, hey, I'm Reebok, your Leebok is a little too close to mine. The government didn't catch it, but I caught it. Stop now, right? That's what that opposition phase is for. After that, if you haven't done so yet and you get past that stage, the next thing is you have to prove use in commerce if you haven't already. And then lastly, once you're in use, you'll have a registered trademark. So let's take a look at the application requirements. What is the bare minimum that can be on an application that you file? There's 4 things, right? The first is a clear drawing. The clear drawing, I don't mean that you actually physically draw on the application. It's not like that. It's the name of your trademark, or it's the logo or the bottle shape or whatever it is uploaded in. So the government has that. Next is the listing of goods and services. So trademarks are for, as I've said a couple of times, they identify your goods and services. You can't have a trademark that just carte blanche covers everything. Think of Dove. There's Dove soap, right? There's also Dove ice cream, right? They're not the same company. The soap company doesn't make ice cream, I hope. They don't. After that, you have to determine your filing basis, and that's a requirement for the government. There's several different bases that are out there. There's international filing bases, there's lots of things, but it really comes down to 2 main ones here in the US. There's an intent to use basis, a 1B, and that means I'm not using this trademark yet, but I plan to soon, right? Or there's an I'm already using this trademark, an in-use trademark, a 1A, meaning I am using it, and here's the proof, right? That's the 2 main bases that most people use here in the US. And then lastly, you have to pay the government their fee. So what is that fee, right? The government filing fees. Just to kind of touch on this really quick, currently the government has 2 application styles. It's a TEAS Plus application and a TEAS Standard application. The TEAS Plus what that one is, the government's done the legwork on the back end for you here. They've made a whole list of goods and services and their descriptions, and all you're doing is picking from that list. So I'm doing this, I'm doing this, I'm doing this. You got to take the time to do it, but the government says, since you used this list, it's going to take us a lot less time to review it, so we're going to charge you a little less money, $250 per class. On the other side, the T's standard application is $350 per class. And the government says, well, in this case, you've decided not to use our descriptions, so we're going to charge you more because we have to do more work, right? That's kind of what it comes down to. There's a couple of reasons you might do a T's standard application, though. One is if either A, you just don't want to go through the long list and find everything that you're doing, or B, maybe what you're doing isn't captured there, right? Maybe you're doing things that the government hasn't made a description for. In which case, you're going to have to do the T standard application in those situations. So, we just talked about the money that you have to pay the government. Why would you file early? Why not save that money and build up and then file later? Well, there's a little percentage here at the bottom, 35%. 35% of small businesses are forced to rebrand due to name similarity or confusion. And this number would probably be a lot lower if brands would simply run their searches and file their trademarks early, right? So first reason why you want to file early, money, right? It's going to save you money to file early. That's probably the biggest reason. But more than that, filing early gives you priority over your competitors, right? So if you file today and a competitor files tomorrow, you have priority over that, right? Because you filed it first in the US. So it doesn't matter if they start using it the next day and you start using it a month later. You filed first before either of you were using it. You have priority. Lastly, constructive notice. And what this is, once you have that trademark, if someone else started using it, and maybe they didn't know about it, right? You know, they just said, hey, this is a cool name, and coincidence, they start using it, they haven't filed or anything else, and you find out about them and you sue them, they're not going to be able to use the, well, I didn't know card, right? Like, oh, it was an accident. The government's going to say, well, you should have known. It was registered. All you had to do was look at the USPTO database, right? These are the reasons why you want to file early. And earlier, I also mentioned that whole priority date thing based off of filing. It may take the government 9 months to review your trademark, but you're protected with the government from the first day that you file. That's why you file early. So after you have a registered trademark, are you done? Unfortunately not. You do have to maintain it. And there's a few things that you need to do for that. One is you have to continue to use it in commerce, right? You can't just use it once and be like, all right, I'm done. No, you have to regularly use it over time. Next, you have to enforce your trademark rights. So the government, they will let you register it, and they won't let someone else register the same name or a similar name, but they're not the police here. They just give you that right to police it for yourself, right? So you have to enforce it on your own. And lastly, you have to file post-registration documents, right? So every so often, after it's first registered, 5 to 6 years after, and then another 5 years, and then every 10 years. If all of this seems like a lot, you can use a trademark attorney. We're all very experienced in all of this stuff to make it nice and easy for you. So let's look at another case study. This one's a real one. This one isn't a made-up case study. This one's real. Who recognizes this bottle? Anyone recognize this bottle? Jack Daniels, right? Yeah, hard to remember sometimes. So even if you don't drink, you probably recognize the bottle though. How about this one? Bad Spaniels. This one's actually not alcohol. This one is a dog toy. But just look at it. Does it look similar? Do these look fairly similar to you? Right? Jack Daniels thought so too. They thought so too. And here's the thing with Jack Daniels. They don't just have their name trademarked. They have the circle trademarked. They have the label trademarked. They have the bottle trademarked. The shape of the bottle is trademarked. You can do that. Coca-Cola has their bottle trademarked too. So when they saw this, they said, this is a little too close, even though it's a dog toy, right? And obviously Bad Spaniels disagreed. But here's what it comes down to. If you see this, if you're walking down the grocery store and you go to the pet aisle and you see this Bad Spaniels, the first thing that's going to come to your mind is, oh, how cute. Jack Daniels has a dog toy. I want that for my dog. You can't do that, right? You're stealing someone else's intellectual property for your own gain at that point. And that's not allowed. And the Supreme Court agreed with that. They said, no, I'm sorry, you cannot do that. That is a violation of trademark rights there. So the point here being is enforcement is important. Protecting everything that can be protected is important, right? So Jack Daniels, had they not protected their label, had they not protected their bottle, they wouldn't have been able to defend against this. Bad Spaniels is far enough away from Jack Daniels in terms of how they sound, but that bottle isn't, that label isn't, and that's what's protected here, and that's why Jack Daniels was able to protect their brand in this instance. So that's all I have for you guys today. We're going to open it up to some questions now. So who has questions either about your own brand, questions about trademarks in general? Let me know who has any questions. We have a question right over here. Had someone with a mic. Here, let's just start here.
For international trademarks, do you have to file one for each country? Is there like an overall way you can blanket it?
That is a great question. So with international trademarks, if you're trying to protect trademarks in multiple countries, you do have to file in each country. However, you can use what's called the Madrid Protocol, and then you can file, let's say you have the US trademark already. You can file in multiple countries at the same time. You have to pay the separate filing fees for each country, but you can put them all on one application and file them all at the same time. Great question. You had a question as well?
Hi, I've been in business for nearly 3 years, and I've had my logo design and all that domain. Is it too late to do trademark?
Great question. No, it's not too late. Now, what you will want to do, though, is run a search, right? Just to make sure no one else has trademarked it in the meantime. Because otherwise you could still might be able to get it, but you might have to go through litigation, which would cost more. It's best to search first, make sure no one has it. But yeah, you should still be able to get it. Great question. Any other questions? Well, if there are no other questions, I'm going to put my contact information up here on the screen. Oh, we do have one more.
If like a trademark can be just a logo or anything like an idea or something else, like a
Great question. So trademarks, they cannot be ideas, right? We cannot protect ideas. Think of it like you go to a blockbuster movies, right? Concepts can't be protected. Like think of like the blockbuster movie season. There's always at least 2 movies that are like exactly the same with a different name and different casts, right? That's because the idea cannot be protected. But that script can be copywritten, right, to protect the actual script, the work. And then the names and the brands themselves can be protected for the goods and services. So you can protect the name, you can protect the logo, you can protect the slogan, right? Nike has Just Do It, right? That's trademarked, that's protected. So all of those types of things you can protect. Yeah. Great question. Any other questions? Yes.
How can one combat piracy between here, especially the one that goes on between the products in the United States and China?
So piracy combating. There's a couple of ways that you can do that. The first thing that you're really going to want to do, once you have a registered trademark, you can then register your trademark with Border Patrol. And then let Border Patrol know where all your products come from, like who your manufacturers are that are overseas. And then when they see things coming in that aren't from those, they're going to seize them on your behalf. That's the best way you can do it in terms of if things are coming in from overseas. Register your trademarks after it's fully registered with Border Patrol. The other thing you can do, obviously, is you can file trademarks in China as well. I would use like the Madrid protocol for that to get that application there, and then that name is protected there, so you don't have to worry about someone seizing the name over there as well. Great question. All right, well, I want to thank you all for your time today. This has been a pleasure. Once again, my name is Alec Allen Ross, the founder of the Trademark Place. You can find my contact information over here, my phone number, my email address. The QR code will take you directly to my website as well. And all of you should have a flyer on your seat. Thank you again, and have a wonderful day.